Good morning, afternoon, evening, middle of the night, whenever you're watching this. Not legal advice. This is not legal advice. Please like, subscribe, share, comment, all those, please. I appreciate it. Just as I kind of started to do, I wanted to say welcome to those that I see in the comments. I see flying. I enjoy doing this, by the way. I see flying, and by the way, I have to give everybody credit for the great names. Flying bus driver, toe cramp, Donna M, Moody Waters, Jasper Reed, Tim Casey, Darren Collins, Tim Naylor, Scott W, the one, 22 J Dog, Lee Willis, Middle Ground AC. I got to stop. Anyway, hello, and hello to everybody out there. Appreciate you joining. Hi, Big JR, and Amolfo above, and Pat. I could keep on saying this, but I'm going to stop doing that. So what I want to do today was to talk about the court hearing that occurred yesterday. Behind me is a picture of a judge. If I move this way, let's see if I move this way. You see the judge kind of back there with his gavel. So that's kind of the topic today. We're going to talk about the court hearing that happened yesterday with regard to GTII and bring up to speed about what all went on. I'm going to kind of go in order of importance. You will see the last topic is the least important, but I kind of will do that in order. We'll kind of go through what happened yesterday, what's going to go forward, potential time deadlines, etc., and we'll go from there. Before we start, of course, I had a couple things to reference to you. What's the difference between an accountant and a lawyer? Accountants know they're boring. What do you call the person who is always smiling and courteous at a bar association convention? The caterer. Why did the lawyer cross the road? To get to the car accident on the other side. And last but not least, what's the difference? And listen to this one very carefully. What's the difference between a lawyer and a herd of buffalo? The lawyer charges more. Anyway, so talking about what happened yesterday, I attended the hearing. I listened to the entirety of it. The motion to withdraw was heard that day, the motion brought by plaintiff's counsel also. So I'll go over kind of basically what was discussed. So I think plaintiff's counsel, David Reichman's attorney appeared via Zoom. In the courtroom where there was the receiver's counsel and counsel for Kathy Griffin and myself. And there were some others in there because there were some other cases that occurred. I think we were the last case, if I recall. But there were some other cases that occurred, so we kind of sat in the courtroom. We started around 9 o'clock Pacific time is when the calendar was called. I think we finished around quarter to 11, 10:30, quarter to 11, something like that. It was in Las Vegas, downtown. So before the court what was scheduled was a hearing on the claims motion, and today what was scheduled was a status conference. Instead, and I had suggested this also, had actually sent emails to various people suggesting it, but I suggested we should combine it, and the receiver's counsel did ask the court to kind of combine things. So it also served as a status conference to kind of keep us apprised of what was going on. So let's kind of go down the items that were discussed. The audit was discussed. The audit is complete, but for the certification, apparently, of 5 law firms. The receiver's counsel asked for the court to give the law firms a nudge to sign off on certain certifications. The auditor apparently needs the certifications in order to complete the audit. All the work with regard to the audit has been done. So it's done, just waiting for these certifications. So the receiver's counsel asked the court for intervention. The court is going to set basically a hearing within 2 weeks, basically giving these 5 law firms who I think the court referenced are subject to the receivership order, but it'll give those law firms an opportunity either to comply or tell them why they're not going to comply. So I expect that to happen within the next 2 to 4 weeks. It's possible, because there's ongoing negotiations, that some of those parties that haven't certified, when they hear that the judge is kind of annoyed, because he was a little annoyed, that they may just sign a certification based upon that alone. We shall see. But we'll know. Hopefully this will be done within 2 to 4 weeks. Once the audit is done, and certainly we'll be able to review it and see what goes on. And that will be a key step, obviously, in getting it back to trade, because it cannot trade unless the audit is done. There may be some other steps that need to be done, but the absolute step that needs to be done is the audit. And so in court, it was discussed, and obviously the representation is it's done. Other than the certifications, the court has acted. In my opinion, this is just my opinion, the court kind of has indicated in all its rulings it understood and understands what's going on. So I don't think there's been a motion or request that's been made that would benefit the receiver and indirectly perhaps us, that's not been granted by the court, including the receivership motion itself. So I don't see any reason in particular why the court is not going to continue to rule in favor of the receivership. Now, the scope of the rulings, what the order exactly says, that might be subject to controversy. But I think the court really knows what went on here and knows the parties, and is going to be on the side of the shareholders from this point in time, and I think has been from the start. And I think he's a really good judge. Happen to think he's a good judge, intelligent, thoughtful, was a practicing lawyer. And anyway, so the order will be issued. So the audit should be completed, hopefully. Hopefully by the end of June. I'm hoping that's when we have all the certifications off, the audit's done, and then we could look at the audit, see what items might have changed, etc. Also, what was heard yesterday was the claims motion. So that was the motion that was filed, and I had spoken about it. And that was, anybody had a claim, like, you had an agreement, some kind of contract with GTII, and they breached it or something like that, you could assert the claim. And that motion was heard yesterday, and the court granted it. So anybody who has to file a claim, it will be referenced, I believe, if you look on the GTII website, I think that's what they reference, that all this stuff will be on the GTII corporate website. And there'll be a claim form. And if you happen to have I don't know how many people this applies to, it probably doesn't apply to a lot of people. But if you happen to have an agreement that was breached and the statute of limitation doesn't run, et cetera, then you might file a claim. I'm not involved in that process, but there will be a form, I believe, that'll be referenced as a proof of claim form. And that's what you're going to submit. You'll submit it to the the receiver or the receiver's counsel. The way it's going to be done, according to the hearing yesterday, is so the motion was granted. So parties now have a limited time to assert a claim. I think it was like 60 days max to assert a claim. Once all the claims are asserted, then the counsel for the receiver will accumulate them, create some type of summary, and then a process will be set up if there's any remaining claims. If there are claims still existing, they will be then a process set up whereby the court will determine which claims are valid and which is not, if there's money to pay, et cetera, all that stuff. It remains to be seen how many claims there are and whose claims there are. It'd be interesting for me to see if the defendants, including Reichman, filed claims. It would be interesting. During the hearing yesterday, one thing that Reichman's counsel, again, appeared on Zoom. I think he's located in New York. One thing he did indicate when there was a discussion about the shares and the illicit shares, he said, not so loudly, but he said, obviously the Reichman side contests that conclusion about the illicit nature of the shares. I don't think he said it exactly like that, but that was the meaning that he said. So that claims situation will be resolved. I don't think it necessarily has to be completely resolved prior to any acquisition. And there was discussion during the hearing also I think on a couple times that the discussions with regard to the acquisition are ongoing. AI-versity was not mentioned, but that's obviously my understanding. My understanding is also that is true, that the discussions are ongoing and they're well aware of what's going on and following it closely and engaged, and those negotiations seem to be moving forward in a positive direction. But the claims situation is a situation that has to be resolved because everybody has to know what claims might exist, and also that the claims will end, so that after a certain date, if you don't get your claim in now, you can't bring it later, and therefore everybody kind of knows what they're buying into. So motion is granted. We will now get a bunch of claims, then there'll be a summary of the claims, and then if there are remaining claims after that, then there'll be some procedure set up to decide which claims are valid. Now, kind of what I mentioned before, it'd be interesting to me if these claim responses require some kind of declaration under penalty of perjury, because then somebody might be perjuring themselves if what they testify about is not accurate. If they testify in an accurate way, then that may not support their claim, theoretically, if you look at the receiver's reports. So I'm waiting to see if, in fact, they take a position, if it's under penalty of perjury, and if they try to dig themselves a deeper hole. That would be interesting to me. But we will see. But the court granted the claims motion, so that's another step, positive step forward towards resolving the issues that are needed to be resolved to move forward with any kind of acquisition. So, my hat is on wrong. How come nobody told me my hat was on crooked? Thank you. Thank you out there for not telling me that. Hey guys, thank you. So there was also discussion about, so we talked about the audit, we talked about the claim motion. Now let's talk about the shares. So that was that, we talked about it last week, I believe, where I discussed the objection that the receiver had in the illicit shares of dubious circumstances. And actually that came up during the discussion, during the hearing yesterday. I think the Receivers Council mentioned dubious a few times, not with the same proficiency and accent that I use, but he did reference the dubious nature of some of those shares. Anyway, there was a discussion about the share motion, which the share motion, to remind you, that was a motion objection that where the receiver went through all the records, or his forensic accountant went through the records, or somebody went through the records, determined that there was 87 persons or entities that had gotten shares that I think he characterized as illicitly obtained shares or dubiously obtained shares without consideration. In other words, nothing was paid for them or nothing was received, etc. So it was discussed at the status conference at the hearing yesterday. The share motion was discussed, and that will be heard on, I believe, June 5th. And it's likely, again, based upon what I believe the court's view is, that that motion will be granted also. And although I can't speak for the judge, obviously, but if he's consistent, or if he deems this consistent with everything else, and I think he understands the nature of the complexity of what was going on there. In fact, one of the things that was discussed, which I referenced in my video and was discussed in the hearing yesterday, was attached to the receiver's report or the motion. Maybe it was the objection. I don't remember which one, but the last report or the objection, there was an Exhibit A attached, and that was like a tree showing all the transactions, all the various parties who was affiliated with, and it all kind of started with Reichman, and then there was like a huge tree. And it was very complicated and very hard to follow, and kind of the judge understood, and it kind of came up during the conversation that somebody doesn't do this unintentionally unless they're trying to conceal things. Now, the judge didn't say it exactly like that, but that was the meaning that came across, that nobody sets up, and I'm just making up numbers, but like 100 different fake companies or shell companies if what you're doing is legit. You're doing it either to avoid something or to accomplish something. And in this case, in light of, what we know based upon the receiver's reports and the receiver's opinions, there's a lot of no good that went on and no justification for that. So anyway, what will happen on June 5th, I believe, is the motion will be heard the court will issue an order. So what will that order be? The motion, I think, is seeking just to freeze the shares. I think the frozen shares, the need for the shares to be frozen or to be canceled, I think it's an and or. I think originally, I thought that the shares had to be canceled, but if they're just kind of frozen, that might be sufficient. But I can't speak for anybody else, but I think it might be for a potential transaction to go forward. So the motion that is going to be heard on the 5th basically freezes these shares and gives everybody whose shares are frozen the opportunity to object and to, I guess, get a court to order that the shares are legit. Now, the information I got yesterday during the proceedings was it appears, and again, I don't have any firsthand knowledge, but it appears, I think we talked about 87 different people or entity that were accused or purportedly to own those disputed shares. Of those 87, it sounds like a large proportion of those have already agreed or in the process of agreeing to give back their shares. And there's some, basically, if they do that, because apparently some didn't even know they received shares. How do you like that? Besides the, apparently a drawer full of share certificates sitting by the management's office. Some people apparently didn't know shares, and we know that there was one guy who was dead, and the mechanic, the masseuse, all that other stuff. But most of them apparently, or most of the ones not linked to Reichman, probably, or a large majority of those will share without litigation, is my speculation, because they won't want to engage the cost. If they didn't pay for them, then they might have a tax event that might be, problematic in many ways. So the kind of understanding I got was as to everybody other than, I think, Reichman, and perhaps Justine Reichman, I don't know. That one I don't know. But everybody other than Reichman, I think most of them are going to cave and they will give back their shares. What that number is, I don't know, but it should be a significant chunk of the 178 million that exists. And again, I don't know how many share certificates were sitting in somebody's drawer. That might be millions too of that 178, but we don't know. Certainly, I don't know at this point in time. So hopefully, as of June 5th, and I strongly support this and the motion of the receiver and the receiver's counsel, I hope that the shares are frozen. And I think if the shares are frozen, that could, along with the completion of the audit, expedite the conclusion of any transaction with AI-versity or whoever the target is. I think AI-versity is obviously the target. I think if those motions, the audit's completed and that motion is granted and the shares are frozen, I think that's a long way to completing this transaction if those parties agree on everything else. So I'm pretty optimistic if that motion is granted. That'll be June 5th. And so stay tuned carefully as to that. And that'll be the objection and setting up a procedure whereby anybody can test it. I don't even know about Reichman, if he has the wherewithal to spend the money to contest that. I don't know. I don't know his physical condition. I don't know his mental condition. I don't know, what is, my understanding is he doesn't have any money or that his money is locked up. I know his condo has a lis pendens, but he, you could set up a bunch of entities. Maybe you could draw on it. I know there's been some trading of the stock I've seen online. I note, by the way, Alpine does trade. I mean, it does act as a trading entity. I think I mentioned that they had another contract. Alpine was the prime broker for GTII. I just mentioned this because I see it trading, even if it's in small numbers. It makes me wonder if Alpine is the one who's trading the stock, or if they are affiliates trading. And I don't know, but it interests me. I don't know, by the way, what will happen with the dividend shares. I think that's to be honest, that's not the priority. The priority is to get it trading, to get a deal completed, and I think whatever else. And I think I'm hopeful that if those two events happen, again, hopeful, not making a financial prediction or a legal prediction, Just hopeful. That's all I am. But I'm hopeful that if it gets back to trading again and there's an acquisition, that the dividend shares will be, I mean, if it's all you got, then it won't be irrelevant. But if the deal goes as I hope it goes and things work out, I'm hoping to everybody that ultimately the dividend shares, I mean, it's not great, but they won't be, it won't kill the deal for you, if you know what I mean. I don't even know what I mean, but I'm hoping that the dividend shares end up being incidental and the transaction works out well enough for everybody that you may not be happy about the dividend, but you're happy about other things. So that's kind of what I'm hoping. And again, I'm hoping that, and I think more than hoping, that if we get the audit done, that motion is granted where the shares are basically frozen of those illicit, according to the receiver, those that have illicit shares, hoping that we can move forward. So that sounds like very positive. The motion's heard in June. I don't know what the order is going to say. Doesn't sound like we're far off, by the way, time-wise. I can't tell you if it's 30 days, 60 days, but I think we're headed in the right direction. The court is aiding us in that effort. The facts support it, and I'm very optimistic. No guarantees. Anything can happen. This deal could fall through. Unexpected things could pop up, but I think as of now, I think we are really sitting pretty in terms of the progress that's being made. Next, and I don't know this for a fact, but my understanding is that, and this might relate to the share motion. So perhaps, the receiver declares that a bunch of David Reichmann shares are illicit or of dubious nature. And perhaps in those legal proceedings, perhaps there's a resolution of those shares. In the meantime, so that's what I'm thinking, that the motion on freezing the shares might also help resolve some of the disputes that exist with the biggest shareholders, because I don't understand why they would be taking the risk of exposing themselves, to all kinds of consequences well beyond just being broke, which, it may be the fact that these guys end up broke or close to broke. According to the receiver's reports, that would be justified under the consequences, but under the circumstance. But let's think about it. So there's a share motion, and their shares are going to be, very possible that the shares are going to be tied up. So in the meantime, I think there's been discussions. I wasn't involved. I don't know specifically. So this is my best understanding. There have been discussions between the parties. That would be between, I don't know all the parties, but I'm talking about the Reichmanns now. I believe there's been discussions at least with David Reichmann. I believe both Reichmanns, but at least with David Reichmann. And I think there was some offer made by the receiver. I couldn't tell you what it was. I don't believe that there was a counter provided. I don't think there certainly wasn't an acceptance by David Reichmann, and I know or my understanding, there wasn't a counter offer. So to me, that's not a real great negotiation. So if it were me, in light of there's a discovery stay right now, which means right now you can't initiate discovery or depositions absent court approval. So you'd have to make a motion to get discovery available. For me, and I was the one running the show, and I'm certainly not. And again, as I've mentioned before, different attorneys can have different strategies, so just keep it as such. But I would try to have discovery opened up, and I would try to take Reichmann's deposition, and I would force him to either make a statement under penalty of perjury or take the fifth, one or the other. And I'd really put him to the screws. So my understanding, that would be what I would do, and that's what I would suggest, and that's actually what I suggested, to be honest. But again, there are complications, there's financial limitations, there's procedural issues. I don't know about ongoing negotiations or the scope of negotiations. Parties sometimes change their positions, all that kind of stuff. So I'm just telling you what I would do, knowing what I know, which may not be the full record. So my understanding is that that those initial negotiations have been unsuccessful in resolving as to these particular people, David Reichman, and that it's likely that mediation will result. So what is mediation? Mediation is a process where there's a third party, an independent third party, could be a judge, could be an attorney, could be anybody, and they kind of act as an intermediary in trying to get the parties to resolve a dispute. Sometimes they're brilliant and really helpful, sometimes not. It just depends. It also often depends on the willingness and interest of the parties to really engage in negotiations. My concern with Reichman is just bullshitting and he's just wasting time. I don't see any reason not to believe that, and that the mediation will just be another way of him, excuse me, using the term, but dicking around and wasting time. Now, if his shares are frozen, that's less of a concern. But in terms of getting a resolution, that would, that would take some time. So I would not proceed with mediation if it were me, unless I got some initial agreement or understanding that they would have some kind of floor. And I'll just explain what I mean there. So let's say, for the sake of our discussion, and these aren't accurate numbers, but let's say David Reichman had 80 million shares. Before I would agree to, and according to the receiver's reports, those were of dubious accrual and of questionable consideration, et cetera. I wouldn't participate. I wouldn't go to and if somebody wasn't negotiating, so if they weren't countering and let's say 80 million, and I said, okay, you give us 60 million and I'll give you a full release. Let's say that was the discussion. And again, I don't know what the discussion was. I just know that they're having discussions. And Reichman didn't respond to that demand. I would not undertake a mediation, certainly not a paid for mediation, unless I got Reichman to agree to a floor. In other words, we will at least offer 20, and I'm making up numbers again, we'll at least offer you 20 million shares. So if we go to this mediation, we will at least put on the table 20 million shares. I don't know if anything like that has occurred in this particular matter. All I know is that I'm not aware of any deal, but I think the process of the shares being tied up will encourage a lot of negotiation. So I understand the reason for mediation. I'm just very suspicious of David Reichman and his the tactics and whether he'll participate in good faith. And I would expect he wouldn't. If you follow the roadmap, I would think not. He's an elderly gentleman. I don't know him, never met him. Elderly gentleman. I heard he's ill. May not, I don't know what his mental competency is. I don't know any of this stuff, but he might be, and I predicted this about a year and a half ago. It might be that he's just trying to run out the clock. He might believe that, his time on this planet is limited, and that if he can get going forward, if he can hang out, then nothing's going to happen. And, let the chips fall as they may after he's gone. I don't know if that's his intention, but I don't trust him and don't trust him to act in good faith. So, a mediation without a floor, I understand different attorneys, different tactics, and if the shares are tied up, then that's helpful. And, I don't think it would prevent a deal from going forward, is my impression, although I don't have anything in writing. But that's kind of where that stands. So before I touch the last and least important topic, I just want to kind of summarize the four things we talked about. I think the four things: the audit, which certification, and the court's going to issue an order kind of requiring a bunch of law firms to sign off. If they don't, then we'll see what happens. There might be a contempt proceedings or something like that. The claims motion was granted. Claims will now be filed. Then they'll be summarized, and to the extent there are claims that are still remaining and viable, then there'll be some process set up where they'll be adjudicated by the court. The share motion will be heard on the 5th. The idea is to lock up all those shares that the receiver says were obtained illicitly, of dubious circumstance, without consideration. And I believe if those first three things happen, audit, claims, shares, that's a long way going forward to a potential transaction being consummated. I don't know that for a fact, no guarantees, but that's kind of my strong impression. Apparently, there has been no agreement between the receiver and Reichman, and either a very limited reply or no reply, but they're going to pursue or considering pursuing mediation, where there'll be discussion about, how are we going to resolve that, what kind of shares you give them back, et cetera, and whatever else is decided. I don't know who's going to be participating in that, by the way, if it goes forward. I don't know if plaintiffs, I don't know if I could be there, I'll certainly be there. I don't know if I have the standing to be there. And so those are the 4 important things. We're making tons of progress. Everything sounds good. The court seems behind us. We're really advancing. I think AIversity is in on this to this point in time. Everybody, I think, appreciates the progress that's going on, notwithstanding whatever disagreements I have with strategy. I'm trying to give you like the honest approach of how things are moving on. Anything can change. Things can change. Now, last and not least, and least important, I'm just going to put it out there just so I am open about it. Me and the Receivers Council don't get along. I've had a couple of encounters that were unpleasant. I just don't care for those people, and I've indicated to them. They've done a couple things that really piss me off, but that doesn't negate the work they've done on the case. And again, different strategies, and this might be just a personal, I don't know how anybody could not get along with me, but this might just be a personal animus that exists from them to me. It's interesting, I've mentioned this before, for some reason, the Receivers Council does not believe that anyone could not do anything for good reasons. And let me put that in English. That means that they don't believe that someone would act in a way other than a monetary way. So they think I cannot be doing what I'm doing unless I'm getting paid by somebody. And again, if anybody has evidence of that, and if anybody wants to pay me a big sum of money, please do so. But obviously, nobody's paying me for this, and I've had a couple encounters, very unpleasant, annoying, and I don't care for the Receivers Council, nor am I ever going to care for the Receivers Council. But notwithstanding that, it doesn't negate the work they're doing. And again, different attorneys can have different strategies. They've really moved the case forward. Just because I think a bunch of expletives about certain of the counsel is the way it goes. But I wanted to put it out there just so you knew it. So you knew that's in the background. It will not affect how I don't think it's going to affect. It won't affect how I portray what's going on. That's why I did it in the order, by the way. I did it in a particular order of importance. It's just more, it's I don't mind, of all things, we're doing things for free and all that stuff, whatever. Working with other attorneys that theoretically are on the same side who are unpleasant is not fun. That part I don't like. So anyway, I put it out there. You now know. In some, things are going very well, and I'll keep you apprised. Next motion is June 5th, as I mentioned. We'll find out what goes on there, and we'll go from there. But as of now, I think everybody agrees that we're making good progress. Things are going forward. And if they continue in this direction, I think we're gonna, not a financial advice, not a guarantee, but I think we're headed in a good place. We're headed towards a good place. So all you out there who watch this, thank you very much. Hope you all have a great day, weekend, night, whenever you're watching, wherever you're watching. I'll certainly keep you apprised as we go on, and take care. Thanks everybody. Be well.